Well, I've seen some videos in my day describing the Kyle Rittenhouse saga, but this one takes the cake. This is a lawyer by the name of Miriam Sadiq, and she has a channel called Trials and Errors, and she's now going to tell us all about Kyle Rittenhouse and what took place, and she's going to analyze this thing with keen legal insight. The title, Kyle Rittenhouse shooting, was it self-defense? No way. Let's see about that. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dredd Show.
And away we go.
Hi, welcome to Trials and Errors. I'm Miriam. Today we're going to talk about Kyle Rittenhouse. He's the 17-year-old from suburban Chicago who one night decided to go to Kenosha, Wisconsin, where there were protests that turned violent in the evenings to protect the community. Kyle bought a gun. He bought an AR-15, but he didn't buy it directly because he wasn't allowed to. He had a friend of his who was, I think, 19, purchase the gun for him, and then he was...
Okay, so first of all, let's do a little bit of research. We should at least know the names of these people. Notice that she said that he went to Kenosha to engage in these protests. The actual truth is he went to Kenosha the night before because the next morning he was going to help clean graffiti at the high school. We have pictures of him doing what? Cleaning graffiti. Somewhere along the line during that day, somebody got a message that there was a need for people to help safeguard a car lot owned by a friend of somebody. It's not clear what transpired there. I don't know if they had looked up online and saw it. I don't know if they got a text message or what. The friend, his name is Dominique Black, and he is 18 at the time, not 19.
Going to transfer it to Kyle when Kyle was of age. Last summer, we know there were Black Lives Matter protests. Jacob Blake was shot 7 times in the back in Kenosha. And of course, people were very, very upset. Kyle decided to take it upon himself to protect one business in particular with a friend of his. It's the same friend that bought him this gun. He had purchased a...
Okay, so she hasn't paid attention to the news at all. I mean, where did she get the idea that Dominique Black owned this business? Dominique didn't own the business. He's only 18 years old. And this man, who is an immigrant, by the way, owned 2 businesses. He had a car shop, essentially a mechanic shop, and a car lot. And they had volunteered to go and protect the car lot, which is located pretty far from any of the violence and protesting that was going on that night. We have video coverage of that. He and a couple others hanging out at the car lot, having a good time, and you could see in the far distance all the mayhem going on. They're perfectly content with just staying there.
A sling, like a military grade sling, to put his gun onto, so he could get it real.
Oh, a military sling. It's a strap. Where did that start? Where did everybody start describing that sling as a military kind of sling? It's a strap. You can go down to the local sporting goods store and buy one. It's for rifles, essentially. And it's not designed to give people necessarily like quick bursts. It's designed to keep the rifle in front of you. And so this mischaracterization as somehow this sling here is this ultra fancy military thing that he bought. It's just a strap. It's a single point strap, by the way, which means that as you're running, the rifle is going to bounce around a lot. So you got to hold it down. And that's what's going to cause Kyle to slow down and for Joseph Rosenbaum to catch up to him.
Real easy if he needed to. And he went out into the night, met up with some other people who also claimed to be protecting the community, protecting local businesses. And at some point he comes across a gentleman who had apparently just been released from a psychiatric facility that day, and he killed him.
Okay, psychiatric facility is a really nice way of describing a mental health care clinic where he was undergoing treatment because he's a nut. He has bipolar disease. He's also a meth and heroin addict. Furthermore, she completely glosses over this to make it look like he was just somewhat of a man who had maybe some mental troubles. No, he has a violent past. He had raped 4 boys ages 9 to 11, served 10 years in jail, so he's a felon. Furthermore, he beat the living crap out of his wife. That's why he was in the mental health clinic in the first place. He's a domestic abuser. He is psychotic. And at night, if you watch him on video, you can tell he's out looking for a fight. He's setting fire to stuff, and also apparently tried to burn a church down, and that's where he first met Kyle and Ryan. A little bit more on that later. And you also notice she always prefaces the word claims whenever she wants to downplay something, where they claimed they were protecting property. No, they were protecting property. We have them on video doing it. They have their rifles, they're standing, and they are telling people, hey, just move on down the street. We don't want any trouble here. Move on down the street. We're just here protecting the property to try to keep people from burning it. So, but she's going to say, oh, well, they were just claiming to. So this is how one way to bias your narrative, and that is by putting the claim in front of all of these. However, whenever she wants to bite into Kyle, she won't use that terminology. She will move away from it, and it'll be like a certainty in the way she describes it.
Needless to say, shooting an unarmed man, it attracted some attention in the neighborhood, which was already, it was beyond a boiling point at this point. It was already on fire. And we can talk about the difference between peaceful protests and riots, but I don't really want to, because I want to talk.
I just want to interrupt for a moment because I want to say, she said shooting an unarmed man. He was grabbing hold of Kyle's rifle. He's not unarmed. Once you get a hold of somebody's rifle, you're basically taking the rifle from them and arming yourself. Furthermore, the other thing she doesn't mention, as a convicted felon, he can't possess a rifle. So she makes a big deal out of the fact that Kyle's walking around with a rifle. He's underage. He's trying to take a rifle from a kid, and he is not allowed to have a rifle. He is actually committing a felony by possessing that rifle. He's trying. Kyle prevents him from doing so. She's not going to mention that part, though.
Talk about the law of self-defense as it relates to this particular incident. The entire issue with
yeah, your description of self-defense isn't going to be anywhere near what Wisconsin's description of self-defense is. We're going to see that in a moment, where she's going to make every mistake in the book when describing what the self-defense laws are.
Respect to protests and riots is a much deeper, much more philosophical conversation that I think is better suited for another time, when we're not busy talking about people who show up with AR-15s at night during protests and riots looking for trouble. Kyle was...
Okay, so here's the issue, and a lot of people have missed this. She probably comes from a city. I don't know much about her background, but I would bet she probably lives in New York City or Washington, D.C. or something like a major metropolitan area. And they just don't understand what it's like to have people walking around with rifles. But if you were there in Kenosha that night, you will see almost everybody is armed. There are tons of AR-15s being carried around. We saw one kid who was essentially brandishing looks like a bolt action 270 or something like that with optics on it. It was like he was going out deer hunting. And by the way, the worst possible weapon to have for a protest to guard anything in short quarters is a bolt action with optics on it. I mean, I'd rather have a bow and arrow myself. However, she doesn't understand that kind of climate. And so when she hears the story about young Kyle walking around with an AR-15. By the way, you know she has to mention AR-15 over and over and over again. Well, to them, that's that spooky gun that has all that mystique behind it. But it's a rifle. It's like a rifle as far as Wisconsin state laws are concerned. They make no distinction between an AR-15 and any other long rifle. So here she is. She hears about this kid walking around with a rifle, and in her mind, in an imagery, she sees peaceful protesters chanting BLM, BLM, like they're legally allowed to. And here goes Kyle walking around with his AR-15, scaring the bejesus out of everybody. Didn't happen. We went through this. This is one of the videos I presented, and I showed the reaction of the crowd to Kyle and his rifle. There was no reaction. There are so many guns out there that night that nobody pays any attention to any of them. And we have multiple instances where we have that one kid who was brandishing. He's got his rifle. He looks like he's ready to shoot somebody. And this one black girl just walks right by him. Doesn't even pay any heed to him. She's not scared of him. And there wasn't a single person there that night that appeared scared of Kyle and his rifle. Again, it's common in rural areas. I come from Oklahoma, and carrying open rifles like AR-15s is common. We're used to it. But to her, she's not, and she doesn't get that. And so this is also another problem with a lot of foreigners who view these events, and they think they had a kid walking around with an AR-15 rifle. Oh my gosh. But that's not unusual.
I mean, there was a kind of a mob that surrounded him at that point, and he may very well have felt threatened. He was down on the ground, and there's a video of all of this. I mean, of course, these days everybody just pulls out their phone and watches it all take place and then uploads it onto the internet. And Kyle says he felt threatened. One of the people had a gun, and so of course he did the only reasonable thing, which is shoot 2 more people. One of those people ended up dead. The other one was seriously injured. It turns out that nobody actually had a gun. One of the young men had a skateboard.
Okay, and I think most of you out there, I think even the anti-Kyles, those who are convinced that Kyle must go to jail, went, oh no. How could she blow this? I mean, I can't imagine how she could not know that Gage Grosskreutz, who is the person she's talking about, actually had a gun that night. He pointed it at Kyle. It's on video. We have still frame photos of him, and it's a gun. And he admitted it after the event was over. He even went on interviews to explain that he was illegally allowed to carry that gun. That's a little bit contentious. I have other videos on it. I have like 3 videos on Gage and his carrying of the handgun. So here she is. This is in February 2021, and she still thinks that Gage was unarmed. Incredible. She has not paid attention to anything associated with this story.
It's true that, I mean, these people were not happy with Kyle Rittenhouse. They were really displeased that he had shot and killed someone just a few moments before. You know, leads me to wonder, is it self-defense? I think if you review the video, when you see him shoot these 2 people when he's on the ground, you could believe that. You could believe, yes, this is a legitimate self-defense claim. And let's talk.
Yeah. Why? Because he's on the ground. He is on the ground and they're attacking him. Oh, by the way, I should have mentioned that skateboard she's talking about earlier. Guess what? Skateboard is a lethal weapon if you hit somebody in the head with it. How do we know that? Well, we have a Eureka man that was killed by one. He was struck in the abdomen and he died from internal injuries. Any hard object that is aimed at the head is a deadly weapon. Can a skateboard cause death or serious bodily injury? It doesn't have to kill somebody, but it has to be capable of inflicting serious bodily injury. Can a skateboard do that? Oh, hell yeah. Hell yeah. These things, they're not the little cute ones that we used to ride around on when we were a kid. These are pretty good size objects. You swing that at somebody's head, you can knock them cold, and you can give them a concussion, and you can kill them. Gage was armed with a pistol. He was armed with a skateboard. And by the way, she kind of neglects to mention that Anthony Huber, the skateboarder, actually caved it against Kyle's back of his head, and in fact gave him a pretty nasty bruise that was discussed by the police captain. So it wasn't that he missed. He hit Kyle with it.
A little bit about what self-defense is. Self-defense in most states is an affirmative defense, and what that means is that the state puts on its case and it says this particular thing was a murder. It lays out the elements of murder during the course of the trial. It will introduce witnesses potentially who say they saw you do it, you admitted to doing it, there may be physical evidence, DNA, fingerprints, videotapes, what have you. Once they've presented their case, it's up to the accused to prove self-defense. If you say
Wrong. Dead wrong. I don't know where you are coming from, what state you are wrong, but you are not only wrong, you're demonstrably wrong. First of all, she doesn't know what affirmative defense is. That's not affirmative defense, what she's describing. Affirmative defense is a defense that you take when you commit a crime, or at least you commit acts that fit the definition of a crime. You agree to have committed those acts because you're going to claim that other extenuating circumstances release you from responsibility for taking action. For example, the most common, self-defense. So there is a law against attacking somebody, especially with a firearm. There's in the law, I can show you the statute. And by reading that, you think, well, Kyle is guilty. He did these things. And Kyle will go on and say, yes, I did those things that this law says is against the law, is a crime. However, with affirmative defense, he's saying, but I was acting in self-defense. So an affirmative defense is one where you admit to committing the elements of a crime, but then you turn around and you claim that in so doing, you are not guilty because of other extenuating circumstances. And I can't imagine how she blew this. She might be talking about civil law. I don't know. But let's give you a couple of examples of a case where affirmative defense is an important concept to understand. The one example is one that I disclosed yesterday in the case of Marissa Alexander. She goes over to her estranged husband's house and takes a shot at him, doesn't hit him. It looks like she tried to, and she missed. And by the way, she had a restraining order against her, okay? And when the police arrived, she didn't say, yeah, I tried to shoot him because he was attacking me. She said she fired a warning shot. So she's not taking an affirmative defense there at all. She's not admitting to the elements of the crime of attempted murder. Well, that was a problem. Because if she had hired a lawyer, the lawyer could have told her that taking a warning shot is illegal in Florida. It was at the time. They've changed the law since then because of this case. However, at that time, she could not claim that she only fired a warning shot because doing so would have been a crime. So here, the case that she didn't take an affirmative defense landed her in a lot of trouble. She ended up doing 3 years of jail or prison time. She was facing 60 years for that. Why? There were 20 years maximum sentences, but there were 3 people in the room that she shot at, 3 counts, consecutive 60 years. Luckily, she plea bargained out and she served 3 years, which I think is much more amenable or much more reasonable considering that she actually didn't end up shooting somebody. The fact that she missed has to be taken into account. My gosh, I mean, she might as well have murdered all 3 of them if she's going to get 60 years. So that's an example where you have to take an affirmative defense to be able to put up a defense. And there's another one in the state of Wisconsin, Cleghorn versus Wisconsin. So here's a man who shot another one, and he appealed his conviction because he claimed that the judge did not give jury instructions on self-defense. The appeals court denied him. And why? Well, because he claimed that he did not try to actually shoot the attacker. Well, he's not taking an affirmative defense at that point. He's not admitting to the elements of the charge against him, and that is attempted murder. And so the appeals court came back and said, you can't claim self-defense because you admitted that you didn't try to shoot your attacker. And therefore, it's really important that you understand what affirmative defense is. One of the things that's important is if you end up taking a shot at somebody or shooting somebody especially, call your lawyer. Do not try to say things to the police that you think will make it amenable to you because you can often make mistakes. Marissa Alexander thought that she was doing herself a big favor by saying that she didn't really try to shoot her husband. that she only tried to fire a warning shot, but the affirmative defense clause is really important to understand. She didn't know that. She made these statements to the police, ended up serving 3 years for that. Call your lawyer. And guess what? Call a lawyer who knows something about the self-defense laws in your state. Be wary of people on the internet, including me, that make claims about self-defense laws that may not be valid. Don't take anything I say as credible. I'm not even a lawyer. So you don't want to say, well, no, the Dread Man said this and Johnnie Walker Dread said that. No, you need to call a lawyer who specializes in self-defense or at least criminal law in your state. She's not from Wisconsin, and this is getting her a little bit of trouble.
Say it's self-defense, you have the burden of proving it. Otherwise, generally in a trial, an accused, a defendant, has no burden of proof whatsoever. They can sit there silently the entire time, and the prosecution has to bring all of the evidence, and that evidence has to meet the threshold of beyond a reasonable doubt. So what do you have to prove if you're someone who says, plead self-defense? This was a self-defense case. Well, you have to show that you were not the initial aggressor, meaning you didn't do an act.
That's false. This is another misconception a lot of people have who are not familiar with Wisconsin state laws. In Wisconsin, you can even provoke the violence, but if you attempt to flee and you make it known to the other person that you are breaking off the contact, then you reassert your self-defense rights. I went through this in a video. It's in the Wisconsin statutes, and there's a whole ton of lawyers out there who have web pages where they devote space on this, and they all say the same thing. By the way, these lawyers are from where? Wisconsin. You have to know your state laws. She's dead wrong on this. I really doubt that she's correct even in her own state. And she's going to, by the way, make an even crazier statement here in just a moment.
That then caused the other person to basically have to defend themselves, or, was it a fair fight? Were you both involved in this in the same time? Then you have to show, if you weren't the initial aggressor, your fear was reasonable. Were you legitimately afraid, or reasonably afraid rather, that you would be seriously injured, you would face serious bodily injury or death? Now, the whole reasonable person standard is really interesting, considering I believe that the reasonable person was always meant to be a white man in society. So white men had a reasonable belief to be afraid when they were amongst a group of...
Well, she feels on safe ground here. She's obviously a social justice warrior, and she likes to talk in these type of terms, and so she's going to pound this racial thing going forward. But let me explain the reasonableness to you. And the question is that if a person uses self-defense or is claiming self-defense, the question is that did they have a reasonable belief that they faced death or serious bodily injury if they did not take action? She got that part right. Here's the other part that she missed out on, and that is, what is reasonable belief? The jurors will be instructed to consider what would a reasonable person of moderate or normal intelligence and behavior do in this circumstance. Now, you may think, well, that's pretty obvious. There's no difference there between what I would normally think that the defendant would believe. But here is the issue. Suppose that you're a juror and you're a Navy SEAL, or you're a martial arts expert. You might think to yourself, if I was in that situation, I wouldn't have shot him. I would have taken his gun from him. Or another scenario, suppose that you're a real scaredy cat. In other words, you have a terrible fear of being attacked, and you would have panicked, you would have panicked, and you would have opened fire. Neither one of those jurors are examining this the way they should. What they should examine it is, what would a person of normal intelligence and behaviors and beliefs do? And that's the person you have to put into the place of the defendant. Now, Kyle Rittenhouse is a 17-year-old kid and seems to be pretty normal in just every respect. If he had a reason to believe he was in fear, there's probably a good chance that you would have too. By the way, I should go back here and take a look. If I acted in self-defense, I didn't commit a crime, right? And it says here, self-defense is an affirmative defense. And an affirmative defense means that the criminal defendant admits to committing a criminal act, but had a legitimate legal justification for doing so. Not that crap that she was telling us earlier, which sounded to me like just a regular defense. If a defendant successfully presents an affirmative defense, he or she cannot be convicted of the offense. One defense against a criminal charge is to say, I didn't do it. Alleging self-defense is saying, I did do it, but I had to because. See how that lines to what I was saying? Now you may be thinking, yeah, but look, where did he get his sources here? I mean, it's probably some nut job, right? Well, let's take a look here. This is from Nicholson, Gertz, and Otis. Don't know how to pronounce that. And who are they? Well, guess what? Wisconsin legal team. And they specialize in criminal law, and they even have a section on self-defense. These guys know Wisconsin laws on self-defense. These are the people you need to listen to, not her.
Black men, for example, or in a predominantly minority neighborhood. So those were things that somebody could look at and say, well, it would be reasonable to be afraid if you were this kind of person in that kind of place. And I'm not sure if Wisconsin has a stand your ground law. In many states, you do have a duty to retreat if you can.
Do a little research. The answer is no, it does not. However, Kyle was not standing his ground. At what point in the video is he standing his ground? He's running from Rosenbaum. He's running from the mob. He's trying to get away from them. He's not standing his ground. The stand your ground law is irrelevant in this case. And it's especially relevant because Wisconsin doesn't have it.
And safely, unless you're in your home, in which case you have something that's called the castle doctrine, because you know, your home is your castle. So Kyle Rittenhouse's case brings up a couple of interesting points. The first is, if you shoot someone, but it's not the person that then comes and attacks you, are you the initial aggressor? I say yes, because you should not be able to, I don't know, walk into a Target, shoot a person, have a bunch of people come at you to either prevent you from shooting it or, I don't know, just being really angry that you just shot a person and killed him in cold blood, and then have you continue to shoot them.
This is emotional argument. She's not basing it on any statutes. She's basing her argument on what she thinks it should be. And so she's going to create this scenario that says, well, I think the law should be this because what if you were in Target and what if you're doing that? However, I have a different approach. I read the law. What does the law say about these instances? I went through it. A 1-hour video I have on my channel where I walk through the Wisconsin self-defense laws one item after another. There's even a section on offenses to third parties that may have gotten in the way while you're defending yourself. And by the way, that favors Kyle as well. So she's not presenting a legal argument here. It's just, well, what do I think? We don't care what you think. What matters is, what does Wisconsin law say? Well, by the way, she's also dead wrong about proving self-defense. You don't have to prove self-defense. All you have to do is provide the court some evidence that self-defense was in action here, and the prosecution has to prove that it was not. Wisconsin law is really clear on this. Okay, so let's take a look here. This is the Wisconsin jury instruction for criminal cases here, volume 1, and let's go on down here. Self-defense. Self-defense is an issue in this case. The law of self-defense, remember this is the instructions that were given to a jury in a self-defense case. Self-defense is an issue in this case. The law of self-defense allows the defendant to threaten or intentionally use force against another only if, and they list a couple of items here, the defendant believed that there was an actual or imminent unlawful interference. Okay, yeah, we got that. The defendant believed that the amount of force was necessary. We got that. And that the defendant's beliefs were reasonable. Okay, we've talked about that. And down here, guess what it says here? State and burden proof. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. These are the jury instructions. Read them. It's clear. And by the way, there's only about 4 or 5 websites from criminal defense attorneys that say the same thing. All you have to do is type a Google search, burden of proof, self-defense, Wisconsin, and you'll get all kinds of resources. They all say the same thing. So let me be really clear here, because I'm not sure I'm getting out there. In this case, in Kyle's case, all Kyle has to do is show that there is some evidence that he acted in self-defense. At that point, the state must prove he did not. Are we clear? Yeah, I know. Yeah, I make it clear, and then 5 minutes later, half of you are going out there, Kyle has to take the stand. Kyle does not have to take the stand, and nor will he.
I'm saying that, it was self-defense. I don't really know all of the facts of this case, and I don't practice
You don't know any of the facts of the case.
In Wisconsin, so I can't say what would happen in Wisconsin in particular, but...
Well, why not go and read the Wisconsin statutes? I did. Now, for the record, I'm not a lawyer. However, I know self-defense laws. Been at this for a long time. And when I read Wisconsin statutes, I read them line by line. I read case law on it. I even made a video. I made a bunch of videos on it. One of my videos is an hour long. It walks through line by line all of the self-defense statutes in Wisconsin. Guess what? Kyle's getting off. You got not a prayer of convicting that boy. And the reason why is the law agrees with him, not you. So why not take some time out of your day, read the Wisconsin statutes? I mean, I understand that your background in this is based on sort of what you have grown up with, maybe in your own home state, but Wisconsin has very permissive self-defense laws. It has very permissive gun ownership laws. And therefore, you can't apply what is true in your state to Wisconsin. Now, how is this playing also out in Denver? In Colorado, there's one guy who shot a protester who sprayed mace in his face. And of course, there's a charge of murder. He's facing whatever. And a lot of people are saying that, well, Kyle Rittenhouse, they're claiming he acted in self-defense, but they're not protecting this dude. The reason why? Guess what? Colorado laws are a lot stricter in self-defense than Wisconsin. The laws are different. She's a lawyer. Should know this.
From what we know so far of this case, young Mr. Rittenhouse was in the wrong from start to finish. When he was asked by the Washington Post, he actually gave them an interview, and they asked him, why did you bring this gun? He said, well, I brought it because I thought I would be killed. But we know that that's absolutely not true. He brought the gun because he could. That's really it. There was...
Cite your evidence. Cite your evidence. You say that Kyle was wrong, that he did not bring that gun for self-protection. And then you say, and we now know, really? Okay, show me the evidence that he brought that gun to commit any kind of crimes or cause any harm at all. Show me the evidence, because we have hours of footage of Kyle. I have gone through the footage. I have videos on it. We walk through all of his actions that night that's available. And it's lengthy, and guess what? There isn't a shred, not a shred of evidence that he was out there to provoke anything. But here's another big problem for you, and this is going to be a real big problem for you. If you really want Kyle convicted, and you're going to rest it on the provocation deal, too bad. Wisconsin law is clear here. Even if Kyle provoked the attack, as soon as he flees, he reasserts his self-defense rights. So anything that took place up until the time that Rosenbaum is chasing him, not admissible. Well, they might admit some of it, but if you think that they're going to be able to convict Kyle because of what he did to some other people that night, forget it. Not going to happen.
There's no other reason for him to go. And not only that, but he was not legally allowed as a 17-year-old to carry that gun. So self-defense is
Okay, so let's see here. We have a number of cases, and I brought this up. This is a dumb argument. Well, she's made a lot of dumb arguments, but this is one of those dumb arguments I focused on in one of my past videos. And that is, well, if you're carrying your gun illegally, you can't claim self-defense when using it. Oh, yes, you can. You absolutely can. The law does not say that you cannot use a gun that you have illegally to protect yourself. And I brought up a number of cases on this. One case out of Oklahoma, 11-year-old girl. She's in her house. Somebody breaks in. Dude has a knife, by the way. She pulls out a gun, a shotgun, in fact, and shoots him. And he runs off. I don't think he died. Afterwards, they had an interview with her, and like all good Oklahoma girls, she's like, yeah, well, he walked in and I shot him. Oh, it's sweet. I really love her. This was probably about 5 or 6 years ago. At any rate, according to her argument, though, she can't claim self-defense. She can't possess a shotgun. It doesn't matter if she's in her own home. She can't possess a shotgun. That's what the law says. Her mother wasn't home, so she was unsupervised. So according to the argument, she couldn't do that. We had another case near Tulsa where a young kid, I think it was 14, had people invading his home, and he opened fire with an AR-15, killed 3 of them. He cannot legally possess that rifle. In Oklahoma, you have to be 18, unsupervised. And yet, no charges. I understand that when you look at a particular event, it's easy to formulate in your mind what you think the law should be based on the outcome of that event. But as a lawyer, she should know that you have to broaden that, and you have to understand that the law is going to be more generally applicable than on these certain special events alone. And so no state has a law that says that you cannot defend yourself with a gun that you are not legally allowed to possess. And of course, another thing is, Joseph Rosenbaum, he tried to grab Kyle's rifle. He's trying to arm himself with Kyle's rifle. He's a felon, cannot possess a rifle. But nobody ever uses that argument. Nobody ever focuses on that. So here's the deal. If you want to talk about Wisconsin self-defense laws, you got to know what you're talking about. And if you think that Kyle Rittenhouse is going to be convicted because he could not legally possess that rifle, you are in for a major disappointment. You saw the judge, he ain't gonna go for this. All this emotional social justice, BLM, people of color talk isn't gonna go very far there. He is totally impervious to this emotional crap. He's gonna look at the law. The law is on Kyle's side.
It's always tough. In the best of circumstances, it's hard. I don't know how hard it will be for Mr. Rittenhouse and his defense counsel to prove self-defense. In this case,
doesn't have to prove it. Just went over it. In Wisconsin, I think almost in every state, self-defense does not have to be proven. All you have to present is evidence that self-defense could have been a factor. And the prosecution has to prove that it was not. And yes, it seems counterintuitive in some way. Could there be a case where a man wants to kill his wife, and so he shoots her, and then he claims that he was only defending himself, and that places an enormous burden on the prosecution to prove he didn't? Yes, it opens up avenues for attack, and there's been a lot of legal philosophy that's been written about that. But that's the way it is. That's the way the law is stated.
I think, however, he may not be convicted.